Hi, Brent Norling from Norling Law here. I want to talk about a issue that I see frequently in my practice, and that is shareholder disputes. And unfortunately, they happen more often than not, and unfortunately, it's the minority shareholder that usually ends up in a unfortunate position. Unfortunately, what often happens is the majority shareholder, who's often the sole director or at least controls the board, is running the business in a way that is consistent with their control. They think that they control everything and that they have the ultimate say. They usually hold the view that the minority shareholders can't really do anything and they don't have any real powers, and that's particularly the case in businesses that don't have shareholder agreements, which in that SME business space it's very, very common. So as a minority shareholder, you often feel like there's not a lot you can do. You don't have any rights. They control the board. They've got the 51% or more, and if it's 75 or more, it's even harder. But there are rights for minority shareholders, and especially those that are being prejudiced by the way in which the majority shareholder of the board is running the business. And so, one thing I would recommend is, if you are being prejudiced, which I am seeing more and more cases of, particularly in a post-COVID environment where people are doing things that they might not have otherwise done when everyone had a common purpose and they were in the trenches together. If that is the situation, just know that there are rights and entitlements that you have. And in particular, there are protections for minority shareholders in the Companies Act, which can allow, from the nuclear option, minority shareholders can liquidate the company and put into receivership if it's been run in a certain way. Not necessarily the goal, but that's the nuclear option. Right through to requiring the majority shareholders to buy or sell shares. So if you just want out, you can get an order from the court that mandates a purchase of your shares at a fair market value, not the value that the majority may want to buy the shares for, but a fair market value that can be determined by court. So our approach in dealing with these issues is often an educational approach where we educate the majority shareholders of these rights, and we have that as the sword of Damocles that will hang there to allow us to do a deal, because they either do a deal with us at a fair price, or we have that right to go to court. Now, we don't want to go to court. Court's expensive, it's uncertain, and it takes a long time to get a result. So if we can settle early, then everyone can have a win. Look, if you're experiencing these issues, we offer a free 30-minute legal consult. The booking link will be in the description of this video. Feel free to book a consult and we can have a chat about the right strategy. Cheers.